morning, everyone, and welcome to the New Possibilities Hour, part of the Will Work for Food project, first organized by Natalie Armstrong Motan last spring at the beginning of the pandemic. As you all know, these webinars, there's no charge for them. Rather, we ask people to contribute to a food bank if they like what they see. And one of my favorite parts of the program is when we announce the running total of just how generous our audiences have been with food banks around the world. Jean Lawler, would you like to share the good news, please?
Sure, with pleasure. This week so far now we've hit $74,240. So after this program, we'll be over $75,000. So that's fantastic. And you know, any amount, small or large, whether it's your favorite food bank, local food bank, one recommended or suggested by the speaker, whatever it is, anything you can give would be fantastic. And if you can let Natalie know what it is that you've given, or she just keeps track as much as we can. Certainly not everything has been counted, but what has been accounted for that people have told her about, we're going to hit 75,000, I'm sure, after today's program. So thank you so much.
That's fantastic, Jean. Let me add my thanks to our generous audiences in the ADR and litigation communities who've just been so wonderful in helping to fight food insecurity. Today we have a fantastic, timely topic, Trade Secrets 2021, What You Need to Know. And we have a true expert in the field to address us today, Jim Pooley. Jim focuses on trade secret law and management as an advocate, advisor, and neutral. He is an author or co-author of several major IP works, including his treatise Trade Secrets, Law Journal Press, and the Patent Case Management Judicial Guide from the Federal Judicial Center. His most recent business book is Secrets, Managing Information Assets in the Age of Cyberespionage, Verus Press, 2015. The Senate Judiciary Committee relied on Jim for expert testimony and advice regarding the 2016 Defend Trade Secrets Act. From 2009 to 2014, he managed the international patent system at WIPO, the World International Property Organization, in Geneva. He is a past president of the American Intellectual Property Law Association and chairman of the National Inventors Hall of Fame. He currently serves as chair of the Sedona Conference Working Group 12 on Trade Secrets. In 2016, Jim was inducted into the IP Hall of Fame for his contributions to IP law and practice. There is no greater expert. We're so happy you're here. Jim, the floor is yours. Please tell us first about the food bank that you would encourage us to support, and then please turn your topic to trade secrets and tell us what we need to know.
Thanks, Jeff, and thanks everybody for being here this morning, and I look forward to a terrific conversation here. The food bank that I have indicated is the one that I contribute here locally, which is the Second Harvest of Silicon Valley. And it may seem a little strange because of the image that you have of Silicon Valley as, being, stuffed with new billionaires. And it is to an extent, but I think what that's a measure of is the income inequality, which is probably greater around here than it is anywhere else. And we certainly have our share of people who are suffering simply because they can't get enough to eat to begin with. And so that's what makes the work of all these food banks so important. And so our local one is Second Harvest Silicon Valley. So there we are. Now let me start out here. I look forward. I'm going to talk for a little while, and then I think I'd love to get into some Q&A, which in my experience is one of the best ways to bring out some of the things that might be most important to everybody here. And I want to start with a little story that happened when I was a new lawyer in the 70s. practicing here in Palo Alto, which at the time was just a sleepy college town. And like every other litigator, trial lawyer, I took everything that came in off the street, right? No matter what kind of case it was, if it involved a courtroom, then that's what I did. And so one of the things that I did at the time was handle divorces. So one day I got a call from one of my clients who didn't even bother to say hello. She was so upset. And she started out by telling me that son of a bitch, which I understood to be her husband, is taking the kids to his mother's house on the weekend, and she's going through their socks looking for holes and ripping them bigger. I want you to go and get a restraining order against her. And that was the moment when I decided I wasn't going to be doing divorces anymore, that that wasn't why I went to law school. These people, in my experience, might have needed a little bit of legal advice, but they needed a lot of counseling. And so I just went on. I didn't take any more of those. But the other thing that happened, of course, because there's a little story there. I mean, I'm from the East Coast, but I always wanted to come to live in California where there's no humidity and no bugs and all of that. And so in my second year of law school, still on the East Coast, I wrote to every firm in California that had 8 or more lawyers looking for a job, and over 200 firms. I ended up getting one offer from this place I'd never heard of called Palo Alto. And so I landed there just a year after one of our clients had coined the term Silicon Valley. So it happened while I was there. And so that's the other part. If you're a litigator in Silicon Valley in the early 70s, in Palo Alto, well, you end up getting trade secret cases because they happened all the time. And so a lot of what I was doing at the time were these commercial technology cases that involved people who were leaving to start their own company or going to a competitor. And I started doing a lot of these things simply because they were there. Later, after about 8 or 9 years, I was kind of taking stock of all these because I was doing more and more of them. And they were each very different. They involved perhaps different technology, of course, a different fact pattern. But it occurred to me that there was one common theme that operated through all these trade secret cases, whether it was an employee leaving or whether it was a fight between two companies that had been partners on something. Somebody had always done something stupid. That was the common element in all of these cases. So I decided at the time, which was I think 1981 or so, that gee, if I wrote a book about how these cases work and the craziness of them, then people would see what the rules of the road were, and they would never get into this kind of trouble again, and these cases would basically go away. So that was pretty stupid on my part, naive, but it did. I wrote the book, published it, and it did nevertheless, get me a career. And so I got more and more of these cases, and I discovered that unlike the situation in the divorce, where people were focused on trivia for trivia's sake that just only fed their emotional state. In the trade secret cases, there was clearly an enormous emotional component, and I realized that these cases were a lot like the divorce cases that I had handled before, partly with the help of my wife, who was a psychotherapist. And, as I was talking about fact patterns, she would nod and tell me what was going on. And yet they were fascinating to me because they weren't really about who kept the dog or the dishes. They often were about very important issues in the business environment of these companies, and certainly very high impact for the people who were involved, who were, some of them just trying to move to another place and get a new job and so forth. So that became the focus of my practice. I ended up writing a lot and teaching and that sort of thing. And one of the things that I've told my students over the years, the law school students, is, look, when you get out, you're going to be pursuing intellectual property in some way, and you'll probably have a choice to work on a patent case or trade secret case at some point. And my advice is always choose the trade secret case, because it allows you, it first of all gives you a ready-made story. You don't have to go scraping the bottom of the barrel for some human interest angle in order to make an otherwise boring technology case come alive. I mean, it's right there in your face. And the other reason is that lawyers really can make a difference in a trade secret case because of the way that they counsel their clients, even sometimes before everything hits the fan and always after. And that's something that we'll get back to here, because in trying to resolve these cases, sometimes the lawyer is a problem, and we have to move them from being a problem to being a partner and in finding a way out. Anyway, let me just make sure we're all clear and set understanding about the different kinds of trade secret cases that happen. There is, of course, the departing single employee who's going to the competition. That's very, very common around here. And by the way, California has more trade secret cases than any other jurisdiction in the country. And that my educated guess on that is that it has to do with the fact, with Business and Professions Code 16600, which makes it impossible to use non-compete agreements. And so if you're going to protect your technology, you have to trust the employee, and you have to watch them carefully. And sometimes they don't behave themselves, and therefore we get lots of this kind of litigation. So that's one kind. Another is a whole group of employees leaving to do a startup, and that too is fairly frequent, not as common as the first one. Employees who depart in a group to go to a competitor, very common, and each of these has their own kind of dynamic. Then there's a couple of different kinds of what we might think of as business-to-business cases. Perhaps the most common of these is the one where a large business is looking at what they call a make versus buy question, right? Should we pursue this new project inside with our own research and development, or should we look outside for somebody to acquire, or for a license to a technology that's already developed? And unfortunately, frequently they put in charge of that tire kicking project to go out and look at what's available. They put in charge the same person who's in charge of the internal development process. And so they end up getting exposed and infected by the information of all the companies that they're talking to. And if they don't handle their non-disclosure agreements very, very carefully, then they get into trouble that way. And then a close cousin to that is the case where you have large companies that do some sort of deal in which they have to share information with one another. Maybe it's a joint development project. Maybe it's just something as simple as a vendor relationship, but they have to share information, or one side has to share information with the other. And then the relationship goes sour. So, so all of these, the thing that's common, besides the fact, you know, the thing that's common to all these relationships is that there's a trust involved. Either one side or both sides are entrusting the other with some valuable information in some way, right? It's when the small company hires the new engineer out of school, teaches them everything that he needs to know about the industry, about the technology, and so on and so forth. There's a sense of trust in that relationship, and the exposure that employees have to their employers' technology and the things that they're working on is all part of a general sense of, you know, we're in this together. And, you know, it can be that sense of trust can be stronger or weaker depending on the organization. But even within big companies, you have teams where this notion of trust arises. And so in all of these circumstances, what we see is people, you know, coming to have a dependable, close relationship that they get personally invested in. And so that's why when there's a rupture in the relationship, it is more like a divorce than most other kinds of commercial cases, because somebody has been entrusted to hold information, use it only for a certain purpose, and there's an expectation that the relationship is going to continue, and that, you know, everybody is going to continue to participate in the mutual benefits of it. So when there is a rupture in one of these kinds of cases, there's a sense of betrayal, of abandonment, these kinds of very, very strong emotions. You know, the one party looks at the other's actions through a lens that has treachery on it, right? And it's complicated often by the fact that, you know, there are reasons for the disruption in the relationship, and they might be interpreted differently by each side. And frequently there is a disappointment that one side has in the other, and the other doesn't see it the same way. And so that can make things a lot more complicated. So where does the emotional content and reaction reside? Well, it's throughout all the players here. First of all, for the people who are left behind, if there's somebody who has left to go to another company, or a group that has left to either start or join a competitor, you have a group starting with the manager in charge who have been in effect left in the lurch, because typically when this happens, people plan their leaving secretly. They're entitled to do that under California law. You can, if you're not an officer or manager with fiduciary obligations, you can do everything that you need to get started and then just walk out the door, and that's okay. But it feels really bad to the people that have been left behind. And so they start searching for explanations of why this happened. And usually those explanations involve blaming somehow the people who left, who become demonized in a way. And a narrative emerges among the people who are left that that this was their fault. They must have taken advantage of our trust in some way, and they probably are misusing the secrets that we used to share and that undergird the success of this company. And even that can get complicated because there's not, sometimes there's not a uniform reaction to what happened. There may be people still at the company who very much like the ones who left, perhaps feel a little envious. They feel as though, okay, I get it. I can see why they hated that manager who didn't like their ideas and so forth. And the company's coming after them or considering coming after them is really just a confirmation of the worst things that I've thought about this place. So it's not always that you get a uniform attitude, but for the managers who call the shots about whether or not to file litigation and ultimately whether and how to resolve it, they're the ones that hold most of this emotional reaction, and they ride it, and it's what drives their behavior. Then there is the accused, right? The people, the person or people who have left, and of course, they don't see, if they see these really horrible allegations. And of course, it's these days it's very common to compose a complaint in the most purple of prose about the terrible things, stringing together really over the top adjectives, and when the defendants see that, they become really incensed. Now they may have been, getting back to my original comment, they may have been a little stupid in something that they did. They may have missed something here or there. They may have downloaded some documents in order to make sure that they had all of their vacation photos, before they left, et cetera, et cetera. These things happen all the time, but rarely do they ever see themselves as having been a calculated thief that happened to have gotten caught because they were sloppy. Instead, they see themselves as a victim, just as much as the people who are left behind see themselves as a victim. And so they react accordingly, and they get their backup with this sense of victimization, and of course layered on an awful lot of fear, because usually they're in kind of a vulnerable place when these things happen. If they have a startup, they have investors that they have to depend on. If they're at a new employer, they have to depend on that employer's goodwill and understanding as this lawsuit is going on. And then in the straight across business to business relationship, it's a little bit different in that you don't have this big difference in power. You have two entities that are both standalone, and they've had this relationship, and one of them has in effect broken it. The other has discovered it, and they've gotten into a fight. And there it's a lot about the managers who were in charge of the project and their management above them, which is wondering, how did this happen? And so they have to they're spending most of their time scapegoating, looking for the people who, in their view, caused this at the other company. So everybody in these scenarios, and that's my main message here, right? Everybody feels victimized. Everybody is angry. And the everybody I'm talking about, unfortunately, often includes the lawyers. I'm sure many of you heard the story in a case a couple of years ago where a lawyer in a trade secret case at a deposition threw a cup of coffee across the table at the other lawyer, and they ended up, that case got dismissed as a sanction for that bad behavior. But although it rarely gets to that stage, You know, once when I was mediating a case down in Santa Clara Superior Court, I had a lawyer on the case who was so intent on winding up the lawyer on the other side that he claimed that the lawyer that he was directing his attention at claimed that he was packing a gun, so he better be careful, which caused all sorts of bedlam. But in any event, people do get the lawyers involved do get their backs up, and they can misbehave. So you have these. You often, when you get these cases, or if you are the advocate, an advocate that's involved, you need to understand all of these dynamics, because you need to create an exit path for your client. You know, your client probably can't afford either in a real sense of, you know, money and resources, or in the sense of cost for distraction, to take this case all the way to trial. These cases cry out for intervention. And so if you're an advocate, you've got to get it there. You've got to find that exit from the freeway and you know, get it into mediation. And if you're a mediator, then you are confronted with this you know, fist fight that's going on. And so you have challenges that all of the parties have tunnel vision because of the emotions that drive them. This is one of the things my wife, you know, taught me. When you're overcome with these sort of controlling emotions, your peripheral vision just goes away, and you can't see the possibilities around you. Well, I mean, as those, you know, everybody here, I'm sure understands, that's the beauty of facilitated mediation. That is, you can find a lot of possibilities and outcomes that wouldn't have occurred to the combatants. It's a challenge, but not unsurmountable, to get the lawyers to move over to being helpful here, and that's something I know a lot of you have confronted in other environments. But part of the message that's helpful to give is one of the things that I told my students. It's very rewarding in these cases to handle them as an advocate, because you can make a difference, right? You can actually deliver enormous value to your client by being a grown-up and helping them make a sober, clear-eyed assessment of what the risk is that they face in going forward. And that's something you don't often get to do in these giant cases where, you know, the facts just sort of drive the thing forward like a, you know, like a piece of construction equipment. And so getting the lawyers, you know, on your side and understanding what's happening is really very, very important. Now, having said all that, I mean, yes, the stuff of these cases are a challenge, but in my experience, and I have handled over the years, many years now, literally hundreds of these cases as advocate and as mediator. There's opportunity too in the fact that everyone is feeling so emotional, because there was a relationship there once, right? That is something to build on. That is something to explore. What is it that brought these parties together? I mean, you know, again, this is a little bit of doing what I swore I didn't want to do when I was a young lawyer, which is counseling. But, you know, you sort of find out after a while that that's kind of part of the job. And you end up finding ways to remind these people of why they got together in the first place. And that sometimes can open up possibilities that wouldn't be there in a dispute that was really dry and unemotional. You also may be able to find ways out of the dispute that have to do with satisfying emotional needs rather than transferring money from one to the other. I mean, it's really surprising how those kinds of those kinds of aspects to a settlement can be more satisfying than getting money, because you're never going to get as much as you think you deserve. And well, you've all been there. You know about that. It's important, I think, as part of this process, in order to get there, to make sure that the participants do understand the costs that they are incurring, and it's not just about money. In my experience, these kinds of cases, largely because of their emotional content, are very draining and distracting. They become the office soap opera for the company, and they result in a lot of lost time and efficiency and so on and so forth. So helping everybody understand all of that. And this relates actually to one of the sort of nuts and bolts issues here, which is timing. I've found that although like any other case, if you can grab it at the beginning before positions have become hardened, that's good. However, in a lot of these cases, it's not usually possible. But you can do an awful lot at the beginning by setting some ground rules and creating a relationship with the parties so that they stay in touch, because the mediation becomes a longer term process. And in my experience, there comes a time, and there may come a number of times, when the parties sort of pause and think, gee, is this really what I want to be doing? I'm getting a little tired of this. It's not delivering for me the emotional satisfaction that I wanted, right? Even if they don't speak to themselves in those terms, that's kind of what they're thinking. And that's a critical time to grab them, because all of a sudden, the reasons that impelled them forward at the beginning, all of these emotional reactions, have begun to lose their force, and they start, and their vision starts to return, and they can see more. That's a terrific time to be doing this. Just a couple of other little comments, and then let's get into questions. One is on handling really large, complex cases that involve trade secrets. Although it's important to understand these things do, although they can be emotional, they do involve lots of money sometimes. There have been a number of cases in the last couple of years settled in or resolved in 9-figure verdicts, hundreds of millions of dollars. And so that's then into the traditional, let's look at what the risk analysis is based on the expert reports and that sort of thing. Resolving cases like that frequently involve having somebody involved as a special master technical expert that will have continuing obligations to look at what's happening with the defendant and report back. Those things have to be very carefully negotiated. It's possible to find people who can do that, who are sufficiently trusted by each of the parties, but that's going to be part of the challenge in bringing people together. Find out ways, given the fact that their relationship of trust has been ruptured, how can they enter into a new agreement that essentially relies on trust. The last thing to keep in mind is that you may have a multi-party case in which one of the parties, typically an individual employee, has an arbitration agreement. And so their dispute is following a separate path that's not informed by discovery. And so there may be inequality of information access among the parties that will be a bit of a challenge to you as a mediator. So I want to stop there, and I can see in my peripheral vision that a number of things have come up in the chat. So maybe we should. I don't know who's going to oversee the Q&A.
Jim, thank you so much. That's a tremendous presentation, so insightful. I know we all appreciate it. I'm going to start with a question. I'm going to have to drop off the line in a few minutes, and Jean and Natalie will continue. Now, let me follow up on the point you made about sooner or later clients finding a need to move on. And I think that so many of us in mediation have experienced those moments where something sort of changes from a fresh wound to ancient history in the lives of the participants. What can we do either as lawyers representing these parties or as mediators to help catalyze that transition, accelerate that transition from a situation seeming like a fresh wound to a situation seeming like part of the ancient history of someone's life?
Well, I'll just say one of the ways I've done this as an advocate, a counselor to my client in these sorts of things is to engage them about what they're doing now and what their new products are, what markets are they working on, where do they expect to go with the company, and so forth, and just really show genuine interest in that and try to help them get into a conversation about the present and future. And you'd be surprised what comes out of that in terms of shrinking the sense of the past wrong.
Might you ask, Jim, how does this lawsuit fit into or contribute to the achievement of your future goals?
Sure, at some point, but part of making this work is not to reveal what you're doing, right? By engaging them in that. You let them come to their own conclusion as much as you can, as I'm sure you know.
There's a question in the chat about evaluative approaches, facilitative approaches. While every case is different, are there some general rules or general things you and other trade secret experts like to see from mediators in cases of this type?
Yes, and for me, in my experience, a mix works well in this sense that at the beginning, the mediator, because of the highly charged emotional environment, the mediator has a challenge in establishing trust, and so, and the parties too are very highly charged. So to let some of that charge dissipate, it's useful just to facilitate listening at the outset, so as to bring down the heat. That's really, but I think none of these things really resolve successfully without evaluative process that turns on at the appropriate moment, because people, again, people can't see the possibilities themselves, and they look to the mediator ultimately for the kind of advice how do we get out of this box?
Okay, there's a question in the chat from Richard Lutringer. Isn't an employer almost compelled to sue the departing employee with trade secrets to avoid abandoning the right to enforce against others?
And a good question, but I mean the direct answer is no. The only requirement that you have as a predicate to enforcing your trade secrets is that you have taken reasonable measures to protect them up until that point. If you have allowed somebody to leave and take things with them, and they're flaunting it, and it's clear that you've kind of let something go that you shouldn't have, that is definitely going to be a problem. You can't just sort of sit by and let the and let this kind of misappropriation go on and ignore it, or else the next person will be able successfully, to say you've more or less abandoned your trade secrets. But I hasten to add that most situations are not that clear, and you may not be, first of all, aware of what it is that someone has done. And because whether or not there's actually been a misappropriation is very ambiguous and hard to figure out, if you don't act with respect to certain people whose behavior isn't terribly obvious, then that's probably not going to be a problem for you if somebody else engages in a more egregious theft afterwards.
And Jim, are there any boneheaded things you've seen mediators do that we should be sure not to do when we're working in these sophisticated trade secret cases?
The most frustration that I have had as a advocate counselor in these situations is with mediators who fail to engage. It's the mediator that's overly just facilitative and doesn't step up, try to understand what's going on, and grab people and work with them. And I find that hard to understand. But that's the biggest failure in my view. The ones who seem to be radioing it in, who are just there, look at it and they say to themselves, perhaps, these people hate each other. There's no way that I'm going to be able to resolve this. And then they internalize that thought and they act on it, and they don't do anything to move the dial. That's the worst.
Thank you. So Jim, I'll start and take over here now for Jeff. So there was another question here in the chat. California has a bad faith provision authorizing attorney fees for improper prosecution or defense of trade secret claims. Do you see this issue arise in mediation very often?
It's there, but it's not something that, in my view, really moves the dial very much in the discussions, because it's a pretty high bar, either to get enhanced damages because the misappropriation has been willful and malicious, and that's conjunctive, willful and malicious. That's very hard. And to demonstrate on the other side that the action was brought without any reasonable basis is also very, very difficult. So it can enter into it. In cases, it can be meaningful in cases where there's strong evidence of willfulness in the theft. But I'd say a tiny percentage.
Yeah, I think people use the bad faith threat in many different levels, whether it's a contractual dispute, an insurance dispute, or whatever, that it sounds worse than in reality, the way that it can end up, because it is so hard to prove up. So thank you.
Exactly. I mean, if you're looking at it as a risk factor, you identify the risk and you determine how likely is the risk to occur, right? And in this case, the fee shifting or enhanced damages only come around meeting a very, very high threshold of proof. So it's usually, tick the box, we've looked at it, but that's not going to drive the outcome in a settlement.
Right. Insurance, general liability insurance policies provide coverage for advertising injury, which is a defined term. It's certain things. It's not everything, obviously. So when you get into some of these trade secret mediations, you're dealing with an insurance company who may be defending an insured for only certain claims for which they would indemnify, and then lawyers who may have been both a panel counsel for an insurance company, personal counsel, coverage counsel for the insured, coverage counsel for the insurer. How is it that you tend to deal with that? I mean, I know I went many times to these kinds of mediations, and it was because of those reasons. So what thoughts or comments, observations do you have on dealing with insurance in the context of the trade secret types, advertising injury types of mediations?
Yeah, well, listen, I wouldn't presume to talk to this group, but given your experience in dealing with insurance issues in many different contexts, and because we know it can complicate, it can facilitate some outcomes, but handling the insurance coverage issues is its own very difficult task. And all I can say is that the insurers, over the decades that I've been doing this practice, have become very good and adept at writing their CGL policies to exclude the kinds of things that are typically asserted as misappropriation. Remember, misappropriation is an intentional tort. And so to the extent that the case involves classical trade secret claims, you're not going to get coverage. It's only when the plaintiff's lawyers are clever enough or thoughtful enough to include some other claims that might trigger coverage that you can get the insurers involved. And then, you're trying to figure out what's the tail and what's the dog. So, all I can say is that the insurers have done everything they can to tighten that up and to avoid exposing themselves on misappropriation claims.
Are there good ways for mediators to start working in this area, or to start, building a reputation and expertise in this area? Is one of the questions here in the chat.
Well, there's a lot of case law out there for the reading. I'm in the process now of doing believe it or not, my 46th semi-annual update to my treatise since 1997. And so every year I read probably 400 cases. Part of it is sort of figuring out which ones matter and so on. But one of the interesting things about if you get into reading about trade secrets is that you see the stories. They're all individual stories of how these things came apart and so on. And so if I were trying to sort of get into this, the way that I would go about it is, reading up on it a bit. My business book, the one that Jeff referred to, that Secrets Managing Information Assets in the Age of Cyberespionage. It's not long. I wrote it without any footnotes, and it basically describes what this area is all about. And it's written so that a business executive can understand it. So if you start to do that, and then you map out for yourself, what can I as a mediator bring to a case like that, given my experience that I've had that's analogous and applicable to this, then all you need to do is, publish a post, go speak to a group of lawyers about what you can do as a mediator with this kind of case that is particularly suited to misappropriation, and then you're off and running.
Thank you. We've got a number of questions popping up now here in the chat, so we'll just keep on going down the line. Now, where do you see the law today regarding the status of protecting customer lists and items such as a restaurant's food recipes as trade secrets?
Yeah, both of those are protectable trade secrets. They're classical ones. And the law really hasn't changed very much on either issue. We have a lot of examples in the published cases in that area. Generally speaking, customer information, that is the reasons why particular customers buy, their sensibilities about certain products, and or if you're selling insurance, knowing when their policies are up so that they're going to want to renew or not. All of that information about customers is very protectable. And in some cases, the identification of the customers can be protectable too, as long as it's not something that's really obvious and easy to do. The measure for judges in deciding these cases is how easy would it be to replicate this information? And if it's a very modest effort, if all it takes is going on the internet and trying to find out where are all the the beehive manufacturers in Wisconsin, you can probably do that without a whole lot of effort. And so to a certain extent, identification of customers on a list is harder to protect today than it was before information became so readily available. But generally speaking, again, it's just that measure. Would it be really hard to do this or not? And as far as the restaurants are concerned, it's usually who has access to the recipe, and a lot of the cases are about, well, they kept it in a 3-ring binder in the kitchen, and anybody could go and look at it, and so it's not really protectable. Or a judge will say, you're kidding. You're telling me that you have a secret recipe for chili that depends on just adding another ½ teaspoon of salt to 5 gallons. That's a variation that's too trivial to.
No, it's adding that brown sugar to it or something like that. That makes it so special,
Yeah,
Anyway,
particularly if it's counterintuitive, right?
Right. Yeah, or what grandma would put her vanilla in, whatever, and there you go. That's the secret ingredient. Okay, quickly here, because we're close to running out of time, I want to try and get these in. Following up on the insurance discussion, this question is in the chat. When insurance companies are involved in trade secrets mediations, and that's because there's been some sort of advertising activity that falls within the insuring agreement, not excluded, et cetera. Do you see them being a productive part of the process?
Oh, that's sometimes yes, and sometimes not. I mean, look, we all understand the motivations of the insurance company, which is to get out for as little contribution as possible. And if you can figure out a way to harness that motivation as you're trying to piece together a strategy for a useful outcome in the mediation, then yes, they can be helpful. Otherwise, I mean, they create a lot of distraction and noise.
Okay. Here's another question. How would you handle someone weaponizing, is the term that's used, the mediator confidentiality protection to further the negotiation, high settlement demand, for example, of a matter that through evaluative mediating in private caucuses, the client discloses information. Let's see here. Just a second. Sorry, I lost the thing. The client discloses information that negates the claim.
Yeah, well, this is where the best mediators, evaluative mediators, show their stuff, because part of your challenge then is to help the party understand that they can't run away from the bad fact, and you, however, can help them, contextualize it and use it in a way that will still get them a decent outcome. But at some point, if they're trying to hide something that ultimately and you can convince them they won't be able to do, then you really have a lot of power in your hands to move them to a place where they realize that you are the only one who can sort of figure out how to make this work. But the mediator has to grab it and recognize it for what it is.
Okay, great. There's two more here, and we'll be wrapping it up after these ends. We're almost to the 9 a.m. Pacific time clock on the clock here. So the next one is, these are costly cases. Do you see a lot of litigation funders involved? How do you see them affecting the process, and how do you deal with their effect?
Well, that's an interesting question. And if you go on my website, which is Pooley.com, you'll find in the articles section, most recently, an interview that I did with a litigation funder about trade secret cases and this very issue. And one of the advantages that litigation funders have brought to the party is that they pay to evaluate these cases to begin with, and that helps ensure that whatever it is, the case is going to be tethered to some real business goals that have to do with money, and much less so on the emotional content. And I think that's a good thing, creating that filter.
Okay, great. Last question. Do these cases ever cross international borders? And if so, how does that affect the process and the outcomes?
Oh, again, that's a great question. Increasingly, these cases are cross-border. They've been for many years within the United States in different states, but also now internationally. And we have a number of cases, of course, that involve China. And so one of the things that we've noticed, of course, is that unlike patents and copyrights and trademarks, trade secrets are not territorial fundamentally. They're about a relationship. And so the hurt in that relationship can travel with the people and with the effects that happen anywhere in the world. And so we're having to deal with issues of extraterritoriality. US federal law on trade secrets now has been declared applicable to acts that happen completely outside the US. And so a lot more of these cases will be cross-border, I think.
Okay. Well, thank you so much, Mr. Pooley. Before we close here, though, a couple of announcements. First of all, I'd like to make sure everybody realizes that next Thursday, it's mediation from the general counsel's perspective with a gentleman named Robert Mann. He's of counsel to Beck and Poliakoff and general counsel to the Ultimate Software Group, Inc. And then the following week after that, we will be so pleased to have a return of Dean Song Richardson from the University of Irvine Law School. Remember, she was on calendar to speak, and then there were fires in Irvine on the morning of her presentation, so it had to be rescheduled. So February 18th, the 2 weeks hence, will be that one, and she'll be talking about implicit bias and what to do about it. So fantastic speakers. Thank you, Jim. Natalie, you have some updated information for us?
Jean, I do. First, I want to say, Jim, thank you so much for contributing. I mean, fantastic insights into trade secrets. We really appreciate it. And big announcement, during the course of your presentation, Mr. Pooley, we topped the $75,000 mark substantially. We now are at $76,328 donated. And I will encourage all of you, if you can, give $1, give $10, give more to the food bank of Mr. Pooley's choice, which is the Second Harvest Food Bank. And their website is shfb.org. And for each dollar you donate, every food bank can provide approximately 10 meals. So even a little makes a big difference. Thank you all so very much.
Thank you, everyone. Have a wonderful day or evening.
Thank you.
Bye.
Bye-bye now.
Bye. Thank you again.
Bye.